Thank you very much. So, okay, as you heard, my name is Ante Vojković. I come from Croatia, where I work as an attorney at law in law firm Stanić and Partners LLC. Today, my topic will be analyzing and showing you the results of my research and my work, since this topic is really common in my work also. I will do this topic from both international point of view, but also I researched and wanted to go into details of Croatia when it comes to these two conventions. So yeah, I think it's important to encompass both perspectives. So we can start. Short overview first. In my presentation, first I will shortly and briefly say what were the goals of my research, what I wanted to discover, which questions I wanted to answer. After that, I will also briefly show my techniques to do that, what I wanted to do in order to find the answers. And after that, the most important part of my presentation, like the heart of my presentation, will be findings. I will tell what is my research findings. And of course, I will conclude with conclusions. This slide, I will not go through it. This is the reasons why I chose this topic. I think we don't have much time for me to go through this, but I think it all can be summarized into this picture. I really am really passionate about this topic. It's something I love doing, and I really enjoy researching on this. So it really never feels like work or burden or waste of time. I really enjoy it. So that's the main reason. So as you can see, big mountain in front of us. I need to find answers to the questions, and these were my goals. I wanted to meet these two regimes, CLC and bunker regimes. I wanted not just to read them, memorize the provisions. I wanted to go in detail. I wanted to understand their provisions and to learn how to apply them, both in international area, but also in the Republic of Croatia. After that, when I research, when I understand the provisions and regimes, I wanted to develop the criteria on how to determine which of these two regimes to apply in real world. Of course, limitation of liability regimes. Both regimes have like two different mechanisms of how their limitation of liability systems work. I wanted to research on that, of course. Case analysis. For me personally, nothing happens without case law. Cases show us how real life works. Cases confirm provisions and also offer additional interpretation of provisions itself. So I think that was also really important and huge stimulation for me to do this topic because it's full of case law. And of course, at the end, Croatia. These two regimes are international regimes, but of course, I wanted to study Croatian status regarding these two regimes, not just international status, but closely inside the Republic of Croatia. What are the procedural conditions that we must fulfill in order to apply all this in our republic? So my journey to climb this mountain began with identifying legal framework. I divided legal framework conventions into core conventions, CLC and bunkers, because those conventions are substantial law regarding these two regimes, and also corresponding instruments. Those are the instruments that these two core conventions instruct to. We must know them, we must understand them, we must apply them. Those corresponding instruments, of course, are fund conventions when it comes to CLC, and LLMC or any other applicable limitation of liability regime when it comes to bunkers oil pollution. When I identified legal framework, I wanted to make a division. I wanted to compare these two regimes. And why I said essential provisions? Because my topic, I wanted to research on how to claim damage. So not all provisions are equally important. So those important ones that are relevant to claiming damage, I called essential provisions, and I divided them into similarities category and differences. And of course, study on limitation of liability regimes. My journey continued when I covered all the basics, when I understood everything correctly, by analyzing these four cases. I will later show my findings regarding these cases. And of course, at the end, Croatia, apply everything into my own country. So after I did my research, now I will talk about the most important part of my research, about my opinions, my stances, and my findings. So definitely, we cannot not say, we must say that these two regimes have the same foundations. For example, pollution damage. Both regimes cover loss of profit. Both regimes cover actions of reinstatement that are taken or to be taken. Both regimes cover preventive measures and, of course, further loss caused by doing preventive measures. Same foundations theory is also based on their equal treatment of preventive measures. Preventive measures are those measures that are conducted in order to minimize or prevent damage after incident happens. So why I have this bullet point, damage or no damage? Because as Professor Mitya told us at IMLI, preventive measures, even though they apply to minimize or to prevent damage, can also be conducted before actual damage occurred. How we know that? It's easy because we just need to look into the definition of the incident. Incident is one occasion or series of occurrences that cause damage or threat to cause damage. So even after we see a threat of damage, we can do preventive measures. And those preventive measures can be claimed as bunker or oil pollution damages. So we can conduct preventive measures after damage occurred or before, if there is a threat. When it comes to liability, both regimes recognize strict liability, which means that ship owner will be deemed responsible no matter his guilt, and which also means that ship owner will hold the burden of proof. To prove that he is not liable, he will try to prove the existence of exonerations. And exonerations are another same foundation because both regimes have same exoneration reasons. When it comes to scope of application, again, equal treatment of that institute. Both conventions will apply to the pollution damage caused on the territory of the contracting state, including territorial sea, including exclusive economic zone. And also, if state did not proclaim exclusive economic zone, then to the area which is beyond, adjacent to the territorial sea, maximum 200 nautical miles from the breadth from which the territorial sea baseline is measured. But as it was also emphasized multiple times at IMLI, that doesn't happen automatically. It's not like I just apply that provision. State really needs to determine, in accordance with the international law, that area, which is not EEZ, but it's similar to EEZ. So yes, that is a really important takeaway. It doesn't happen automatically. This is exclusions. Exclusions tell us when this convention cannot be applied. Both regimes, both conventions do not apply to warships or to states that are operated or owned by the state. If it is used, the vessel, on government non-commercial purposes, for government non-commercial purposes. If it is used for private commercial purposes, these two conventions do apply. But Bunkers Convention has one addition and one minus when it comes to exclusions. Bunkers Convention will not apply when CLC applies. So if we have the situation in which both regimes apply, CLC will prevail. It has a priority. And also, Bunkers left a possibility to states when implementing the convention to include warships or vessels that are operated by the state. But state needs to do that directly. It's just a possibility. Jurisdiction, again, same foundations, same treatment of jurisdiction. The court that will be competent under both regimes is court where incident happened, where all pollution was caused, or where preventive measures took place. Extinguishing of rights. Again, same treatment. Under these conventions, there is 3 years for possibility to legitimately claim damages from the moment when pollution occurred, or 5 years from the moment where incident happened. 6 years, not 5. So it cannot happen after 6 years after the incident. Ship and oil or bunker oil. For me, this is the most important means of differentiation of these two conventions. This is the criteria which I apply in order to use one or the other. We need to understand the definition of the ship under both conventions and definition of the oil. Bunkers has more broad definitions about oil and about ship. For example, when it comes to ship, bunker says any seagoing vessel or seaborne craft whatsoever. So it's really broad definition. That definition will encompass any definition that undergoes CLC2, because CLC says also any seagoing vessel or seaborne craft, but it must be constructed or adapted to carry oil in bulk as cargo. That's one condition. Or if we have a ship that can carry both oil and other cargo, then that ship must actually carry oil in order to fall under the category of the CLC. Or if we are in the situation of the voyage that is following the voyage in which ship was carrying the oil, if there is a residues of that oil on the ship, that ship will also fall under the category of the CLC. And it will be the burden of the ship owner to prove there is no residues of such oil, which will be seen the case later in real world how it happens. When it comes to the oil, bunkers also has more broad definition. Bunkers says any hydrocarbon mineral oil that is using for propulsion of the operation of the ship. So it's really broad definition. CLC says any persistent hydrocarbon mineral oil that is either being carried as a cargo, or it is also in the bunkers of the ship. So CLC will also cover the oil that is in the bunkers, but persistent oil. So we can easily have a situation in which some kind of oil goes under both bunkers and CLC convention. So in that case, we go to the definition of the ship and see the ship in question under which regime the ship falls, and we apply that convention. If ship falls under both conventions, as I said before, CLC has a priority. Another big difference between these two regimes is the definition of the ship owner. I already said that ship owner will be liable. Ship owner will have the burden of proof to prove that he is not liable, to prove the existence of exonerations. But these two conventions took a different approach when defining a ship owner, which is really important. For example, under CLC, ship owner is a registered owner, person that is actually owner of the ship, registered owner. When it comes to the bunkers, ship owner can be registered owner, it can be operator, it can be manager, it can be bareboat charterer of the ship. So we have extended list of persons potentially liable, which is different than under CLC. As I researched, operator causes most problems because even salvors can fall under the category of the operator, which can serve as a huge disincentive for them. IMO was also thinking about it, of course. So IMO brought a resolution. He urged states, when you implement convention, it would be good to protect the salvors, not just salvors, but any person that conducts any action to prevent or minimize damage, which many states did, including Croatia, which we'll see later. But what about lack of channeling provision? Lack of channeling provision, again, similarity. Again, CLC has a channeling provision. Channeling provision literally protects persons that are enumerated in that provision from being claimed, from being sued for oil pollution damages on the basis on the CLC or any other instrument. So when states ratify CLC, those persons that are enumerated in the channeling provision cannot be successfully sued for oil pollution damage. Bunkers also does not have that provision. So again, salvors are open, not just salvors, but many other people are open to be sued. So we can conclude that CLC has, we can say, almost one possible person liable, almost, registered owner, while bunkers leave space for plenty of persons to be liable, including salvors. Liability, limitation of liability. These pictures already show us everything. When it comes to bunker oil pollution, blue circle, we have general limitation of liability regime. When it comes to CLC regime, oil pollution, we have independent limitation of liability regime. What that means, I will show on my next slide. We can focus now on bunker oil pollution, general limitation of liability regime. Independent, pardon. This is oil pollution, independent limitation of liability regime. 1992 CLC provides the first layer of responsibility. CLC says until a certain amount, ship owner will pay. That will be his limit of limitation. But these cases are causing much damage. So we needed more protection for the victims, more compensation. So how to do that without burdening a ship owner additional? IMO did it with 1992 Fund Convention. It presents a second layer of responsibility. Why? I already said why. Because victims needed more compensation, but nobody wanted to burden ship owner more. So 1992 fund is funded by all contributors. It's regulated in detail in the convention. And on the burden of the fund, victims will receive more compensation than in accordance with 1992 CLC. When does 1992 fund apply? As I already said, when compensation under CLC is not enough, but not only then. For example, 1992 Fund Convention also says that it will apply when no liability arises from the 1992 CLC, which means that entire burden of all compensation will fall on 1992 Fund from 0 until limitations number that 1992 Fund provides. What about jurisdiction? It's an interesting question because it depends. If we have a procedure initiated already under 1992 CLC, then 1992 Fund will follow that jurisdiction. The same court will be competent for 1992 Fund. It will have exclusive jurisdiction. What if the situation happens in which court that has exclusive jurisdiction, that country or that court is not a party to 1992 Fund, but it is party to 1992 CLC? In that case, we go to 1992 CLC, see jurisdiction provisions, and use one of those courts. Or the court where the registered seat of the 1992 Fund is. So everything is covered basically. 2003 Supplementary Fund, it was brought up because of the similar motivation, similar things provoked the adoption of 2003 Supplementary Fund. Supplementary Fund is here to provide for all the compensation, even if second layer 1992 Fund is not enough. But the claim must be established. So there is no suing the 2003 Fund for establishing a claim. Claim already must be established, which means either already recognized by 1992 Fund, or it must derive from court decision that is binding on 1992 Fund, and automatically it will be binding to 2003 Supplementary Fund. So if you sue 1992 Fund, it's almost like you sued 2003 Fund, because it will have same consequences on the additional third layer. So we saw now that in case of oil pollution damage, we have sharing burden between funds and between ship owner. So in order to help a little bit to the funds, to make that share of burden more fair, let's say, more balanced. So to help funds, Stopia and Topia arose. Those are two agreements between ship owners, only between ship owners, that are insured by the P&I Club, the part of the P&I Club Association. And those two agreements told us following. When it comes to second layer, when it comes to 1992 Fund, the ship owner will pay the difference between 20 million SDR and the number that derives from the CLC. That difference will also pay a ship owner, and above 20 million SDRs will pay fund. Topia simply is agreement that says the amount of money, third layer, that 2003 Fund pays, 50% of that amount will also pay ship owner. It is important to highlight that insurance companies are not parties to these agreements. This is agreement only between ship owners, but of course, insurance companies will adapt their policies to cover that money that ship owner needs to pay in accordance with these two agreements. So CLC, independent limitation of liability system that applies only for dead oil pollution damages. Bunker oil pollution does not recognize independent regime. Bunker Convention says that basically any applicable regime can apply, whether international or national. So question of my research was, can I apply LLMC to bunker? The answer was yes. And I had two most important reasons, although the second one is the most important reason. But the first one is simply by interpreting the Article 2 of LLMC. Article 2A1 covers property damage, as it was already said today, and consequential losses that are consequence of the property damage. The question was also about that consequential losses. can 2A1 of LMC cover also pure economic loss, the loss that is not covered, that is not a consequence of property damage? Jurisprudence, especially in APL Sydney case, said yes, it can also cover pure economic loss. But in my opinion, Article 21C of LLMC is more broad. It covers infringement of any right that is not contractual right that appears in direct operation with a vessel. So in my opinion, if it is questionable, can pure economic loss be covered by 2A1? Undeniably, it falls under 21C. Regarding preventive measures, we have Article 21D and 21F. 21D is more concrete, more specific. It covers claims for raising, for removal, for destruction of the ship that is abandoned, sank, wrecked, and similar. That can also be interpreted as preventive measure because it minimizes the damage when we are doing it. But Article 21F is more broad. It covers, as Professor Martinez already said today, it covers the actions that prevent or minimize damage of the persons that are not liable regarding the loss that is covered by LLMC. So in my opinion, even without Article 21D, Article 21F covers everything when it comes to preventive measures and bunker oil pollution claims. But as I said, and as it was already emphasized at Timely a lot of times, this interpretation of Article 2 is not even needed after amendments of the LLMC. Because last amendments in 2015, I think, of LLMC limitation of liability numbers were proposed by Australia and co-sponsoring states. Why? Because of Pacific Adventure case, which was bunker oil pollution case. In that case, the damage was huge. Limitation of liability numbers were not enough in accordance with LLMC. So that was a motivation for Australia to propose to increase limitation of liability numbers under LLMC, which was eventually done, and those amendments are in force. So if IMO increased the numbers of limitation of liability under LLMC because of bunker oil pollution case, that undeniably shows us that LLMC absolutely applies to bunker oil pollution. One more important thing about LLMC, in my opinion, which touches and which is relevant to bunker oil pollution, is this priority ranking of the claims. Professor Martinez already said today that loss of life or personal injury claims have priority, those claims have their own fund, and we have any other claim, property damages. If the fund that covers loss of life or personal injury claims is not enough, those claims will go down to property damage claims, will rank ratably, no priority anymore. All the damages now will have the same ranking and will be satisfied in proportion, or all it will be satisfied or proportion. So no priority anymore. Personal damages become property damages. LLMC also left the possibility to state parties to prioritize certain types of property damages, like damages to harbor works, to aids of navigation, basins, waterways, and similar. If some of the states did that, in this situation, when personal claims go down and rank ratably with property damages, those claims, if state did it, if state prioritized them, will have a priority. No matter the fact that those claims are property damage and personal damages are down, no matter that, those prioritized property damages will have a priority, because personal damage claims, when they go down, they have a status of property damage claims. Continuing with my findings, these findings on this slide are based on my case analysis. I will shortly tell my findings really briefly about all four cases. When it comes to Vojković case, this case showed us the importance of previously mentioned criteria, of previously mentioned importance of definition of oil and definition of the ship. In Vojković, there was an oil spillage, and in that case, the ship was in ballast. Oil that was spilled underwent both regimes, so the definition of the ship decided which regime to apply. Of course, ship owner wanted to apply LLMC because of smaller numbers, but in order to do that, what ship owner had to do? That ship was in ballast, so it was not on the voyage to deliver oil. So that ship owner needed to prove that there is no residues of the oil on the ship that was transferred on the previous voyage. Ship owner tried to do that. Ship owner delivered technical report. Ship owner said that the ship is oil-free in accordance with the MARPOL, but the court declined it, simply for the reason because court said, and court also instructed state parties to 1992 Fund Convention to establish a procedure which should be applied to determine when a ship stops being ship under CLC and becomes a ship under bunkers. Because of that, CLC regime applied, 3-layer of responsibility, which was less beneficial for the shipper. In this case, we could also see the practical appliance of STOPIA, because, as we already said, under STOPIA, ship owner will pay additional money, the difference between 20 million and CLC numbers. In this case, CLC numbers were around 15 and 900,000. So 20 million minus 15, 900,000. That difference was on the ship owner to pay in this case. Regarding Agia Zombie 2 case, just simple interpretation of this case. In this case, one of the claimants tried to claim against the fund without previously trying to claim from the CLC fund. He had his own arguments, but court stopped him immediately. Court said 1992 Fund Convention is extension of CLC. Those two regimes are interconnected. So if you didn't apply for CLC, don't even try to claim from the 1992 fund. Those two regimes are interconnected. If you don't claim from CLC, no fund for you. Volganet case. In this case, I will emphasize only two conclusions. In this case, court gave a really good and detailed description of natural phenomena as one of the exonerations for the ship owner, because insurance company tried to avoid the payment by invoking natural phenomenon. But court said natural phenomenon must be exceptional, must be irresistible, must be inevitable, which means that in real world, in certain area, natural phenomenon must have that character of never happening before, or if it happened long time ago, or if it happened lately, it should not be predicted on weather forecasts, for example, which was not the case here. This natural phenomenon storm was predicted in the weather forecast, and court said master and the crew of the ship didn't do the job good. They didn't predict it, and they didn't prepare, and they didn't react good on everything that happened. So no natural phenomenon invoking in this concrete situation. Most interesting conclusion from the Volgograd case is so-called insurance gap that happened in that case. Incident happened after November 2003. November 2003 is important date because that is the month of the amendments of the CLC number, limitation of liability numbers. And the ship owner was insured by insurance company in accordance with the old, smaller numbers regime, 3 million SDRs. And that moment, applicable numbers were 4.5 million SDRs. So we had insurance gap of 1.4 million, 1.5 million. What court did in the beginning? Court established a fund in accordance with 3 million SDR, old regime. And later, court said ship owner will pay 3 million SDRs, and everything else, entire insurance gap of 1.5 million, will fall on the burden of the fund. Fund disagreed, of course. Fund tried with multiple remedies, and only Supreme Court recognized the real problem in this case. Supreme Court said, first thing Supreme Court said, Vienna Convention says that treaty will enter into force in accordance with the provisions of the treaty. It shall not depend on whether the Russia in their official gazette published new numbers, which was not the case in this situation. That's the reason they said that was the reason they were not insured to the proper amount. So because of that, court also added that first instance court and all other courts did not study this case properly, did not take into account all the relevant facts. Whether insurance company or the ship owner knew or should have known about changes in numbers. And that was the reason the court returned the case to the first instance court and told them to reconsider the entire case. After reconsideration, first instance court changed their stances and said and deducted all the insurance debt of 1.5 million from the victims, which of course did not satisfy the ship owner, who appealed, but without success. Fidelity, I just mentioned 2 bullet points. When I was talking before about how to determine which regime to apply, Fidelity was a livestock carrier. So what that tells us? It tells us that it cannot fall under CLC convention because it's not the ship that is constructed or adapted to carry oil. Its purpose is livestock carrier, so we cannot even talk about where to qualify the ship. We can only talk about the oil. But that's also not important because oil was a residual fuel oil called bunker oil that undergoes both conventions. So oil undergoes both conventions, but the ship undergoes only bunkers. So bunker is to be applied. If ship qualified under CLC, CLC would have a priority and would primarily apply. This case also showed us how international case that includes multiple international parties and subjects to it can lead to pure application of national law, because in this case, insurance company provided letter of undertaking, basically covered all the victims with compensation, of course. But then insurance company tried to apply successfully Article 3, Paragraph 6 of Bunkers Convention that says that ship owner has a right of recourse towards anyone independently of the Bunkers Convention. Insurance company saw that. Then after that, saw Maritime Code, which directly says if the insurance company pays, all the rights that would be on the ship owner will transfer to the insurance company in the limit of the amounts paid. So the insurance company said, I, instead of ship owner, can claim recourses from anyone that I think that is actually at fault. In this case, insurance company thought that entire case is the fault of concessionaire and subcontractors. So in case is still ongoing in Croatia. But the point was to show how national law will become relevant in this international case. At the end, as I said, subject of my research was also my country. First thing to research on was to research international status of my country regarding these legal framework conventions, core ones and corresponding ones. My country, Croatia, is monist country, monist system, which means that all international agreements that are concluded, that are confirmed, that are enforced, will be part of unique legal order and will have a legal strength above law, which basically means that we can directly apply conventions without implementing them. Of course, if the convention is self-executed. If it's not, we must implement. No matter that, Croatia implemented all of the conventions I said, 2 fund conventions, LMC, bunker, and CLC, successfully implemented into the system of the public of Croatia. While implementing it, Croatia put accompanied reservation with the instrument of accession to the LMC. Croatia excluded the possibility to invoke Article 2.1d of the LMC, which is direct removal provision. I already said that provision is relevant to bunker because it covers preventive measures, but it's not out of crucial importance because Article 2.1f in a more broad way covers, when it comes to bunker pollution, same thing. So preventive measures undeniably can be claimed in the Republic of Croatia as well, no matter this reservation. One big difference between LMC regimes and fund convention regimes, CLC regime, is that under CLC, in order to utilize limitation of liability numbers, fund must be established. Under LMC, it does not have to be established. But LMC left the opportunity for states to, while implementing a convention, make it obligatory. Croatia did it, conditioned the establishment, conditioned the utilization of limitation of liability numbers with establishing a fund. So fund is obligatory. As I said before, how bunker oil pollution regime left the space open for salvors to suffer, for salvors to be sued. And as I said, that IMO adopted a resolution in which IMO urged states to protect the salvors and other persons that take actions to prevent or minimize damages. Croatia did that, implemented this resolution and its purpose to the Maritime Code. So under our system, salvors are protected when it comes to bunker oil pollution damages. Other peculiarities of the Republic of Croatia are dealing with procedural elements. Nothing happens without satisfying procedural elements, procedural conditions, because procedural law is the most important law. We cannot go without it. So in order to fight on the court to invoke provisions, we need to satisfy procedural elements. We need to sue before a competent court. Under the Republic of Croatia system, that will be commercial courts. There is undeniably it must be commercial court. We will not go too much in detail. When it comes to local jurisdiction, the plaintiff has a choice, because competent court can be the court of the registered seat of the defendant. When it comes to oil pollution, bunker oil pollution, it can also be the court where harmful actions were done, or the court where harmful consequences appeared. So plaintiff can basically choose the adequate court. Since these cases are often international cases, it's really important to highlight something that sometimes is forgotten, that we need to use Croatian language before Croatian courts. So if we have evidences for anything in a foreign language, adequate translation by the court interpreter shall be delivered. Foreign parties can appear before the courts, can conduct any oral actions, and they will be provided with the translator of what they say, and of course of what is happening generally on that day in the court. But the burden of paying that costs of the translator will be on them. And last thing I want to say when it comes to peculiarities of my country, if we have a company or a person that is not a citizen or does not have a registered seat in the Croatia, in the European Union, or it's not a party to a treaty on European Economic Area, or any other treaty that covers the exemption of paying insurance of litigation costs, that firm, that company, or that person, if it wants a claim in Croatia, if it wants to be a plaintiff, must provide insurance of future litigation costs. The court will make a decision on it, on the defendant's demand. The court will say the sum, the amount of money that needs to be paid. The court will give a deadline. And if the plaintiff, foreign plaintiff, does not satisfy those conditions and the deadline, his claim, his suit will be considered withdrawn. So I would like to conclude in a bit creative way. I would like to summarize everything, okay? So my conclusion generally is that we can definitely say that these two regimes are so-called twins, okay? Because they definitely have the same foundations. There is no question that bunkers is modeled after CLC. No matter that, absolutely, they are not identical. They have differences that we must notice and understand in order to apply them properly. Those differences I highlighted. What about the Republic of Croatia? As I said, the Republic of Croatia ratified and implemented all the conventions. So, the Republic of Croatia definitely represents a good and safe home for these two twins to exist in. But, as I said, it's not everything about international status, about implementing, about ratifying. Procedure is very important. Nothing will happen without satisfying procedural elements. So, in order, we need to have this, we need to satisfy and identify procedural elements because they create a framework under which everything will happen. And only when we do that, as you can see on this picture, these twins will not just live safely, but we will live happily in our life. Thank you.